She was 73 years old, her wrists locked in handcuffs, walking into a courtroom while cameras flashed and strangers whispered loud enough for her to hear every word. The charge: stealing over $300,000 from the government across 18 years. The woman accused, a retired nurse who had spent 3 decades pulling people back from the edge of death in an emergency room that never had enough of anything. Nobody in that packed gallery knew what she had done before the hospital. Nobody knew what she had buried. Nobody knew that the quiet woman at the defense table had once treated combat wounds in places the government didn't officially acknowledge, under conditions that never reached any public report. And nobody, not the judge settling into his chair like a man who had already written the ending, not the prosecutor arranging his charts with the quiet satisfaction of someone who has built something he believes cannot be dismantled, not the reporters filing their early edition stories before the verdict was even close. Nobody knew that 3 men were already in this city. 3 men who shared a last name. 3 men she had pulled out of a broken system with nothing but her own 2 hands and a refusal to walk away. 3 men who had spent the last 72 hours going through documents that were never supposed to be found. Before we go any further, if you're new to this channel, hit subscribe right now because we do not tell small stories here. Every week we bring you cinematic drama that will stay with you long after you stop watching. Hit the like button if you're already in, and drop a comment telling me what city and country you're watching from. I want to see exactly how far this story travels. Now, let's go back to the beginning of everything. The morning Claire Alderman walked into Calverton County Courthouse. The temperature outside was 31 degrees and dropping, and the sky had the flat, committed gray of a sky that has decided the day does not deserve color. She wore a wool cardigan, the color of slate and dark slacks she had pressed the night before at her kitchen table, while the local news played on mute in the next room. She had not watched it. She already knew what they were saying. She had seen her own name on the screen twice and turned away both times. Not from shame, but from the particular exhaustion of watching someone else construct a version of your life that has just enough truth in it to be difficult to argue with. The deputy who escorted her from the holding area was young, 23, maybe 24, with the careful posture of someone who had been trained to project authority and was still figuring out how to wear it naturally. He kept his eyes aimed at the floor ahead of them as they moved through the marble corridor. He wasn't cruel. He simply had no idea what to say to a woman his grandmother's age, being walked in handcuffs past a photographer from the Calverton Ledger who got his shot from 12 feet away and didn't bother pretending he wasn't. Claire didn't flinch at the camera. She had learned a long time ago, in a life she no longer talked about, that the moment you react to being watched is the moment you surrender something you cannot get back. The courtroom was already full when they brought her through the side entrance. She felt the shift in the room as she crossed the threshold, that particular stillness that settles in when something degrading is unfolding and everyone present has quietly agreed to call it procedure. Reporters sat in the gallery with laptops open and fingers resting on keyboards. A group of people from her neighborhood, Fenwick Park, occupied 2 rows near the back. She recognized them without looking directly. Margaret Boyle, who had spent 30 years bringing food to sick neighbors and never mentioned it to anyone. Donna Fitch, who had sat beside Claire through the 2 worst years of her adult life without needing to fill the silence with anything. And at the far end of the second row, Patricia Holm, who had not spoken to Claire in 11 years following a property dispute over a fence line that had never been resolved to either of their satisfaction, but who had apparently decided that whatever had passed between them was smaller than what was happening in this building today. Claire noted all of it. She noted it the way she had always noted things, completely, efficiently, without letting the noting show on her face. The handcuffs came off at the defense table. She rubbed her wrists once, one clean motion, set both hands flat on the table, and did not touch her wrists again. Her attorney, Sasha Brend, leaned in close and said quietly, "How are you holding up?" "Fine," Claire said. "You don't have to say that." "I know." Claire looked toward the front of the room. "I'm saying it because it's true." Sasha had been practicing law for 19 years and had represented clients in cases that ranged from wrongful termination to violent felony, and in all that time she had never once sat beside a client who made her feel like the less composed person at the table. She opened her legal pad and wrote the date at the top and did not push the question further. Judge Roland Merck entered at 9:02 and the room came to order. Merck was 61, recently appointed to the county bench after a long career in civil litigation, and he carried himself with the particular confidence of a man who had confused the reliability of his instincts with the sharpness of them. He settled into his chair without urgency, the unhurried movement of someone who believed the day would proceed according to his expectations because his days generally did. The prosecutor was Douglas Fane, 47 years old, with the aggressively maintained physique of a man who spent money on his health because it was an investment in how people perceived him. His jacket was tailored well enough that the fit was invisible, which was exactly the point. He stood at the front of the courtroom with the ease of a man who had won enough cases that winning had stopped feeling like an achievement and started feeling like the natural order. "Your Honor," he said, "the state is prepared to proceed." "Very well." Merck looked over his reading glasses at Claire. "Miss Alderman, I understand you were extended a plea arrangement that would have brought these proceedings to a considerably more efficient conclusion for everyone involved. I'm told you declined it." "I did," Claire said. "May I ask your reasoning?" She met his gaze directly. "Because I didn't do what I'm being charged with. I won't sign a document saying I did." The judge made a sound. Not quite a dismissal, not quite amusement, something in the space between, and moved forward. Fane's opening statement was clean, well-structured, and precisely as dangerous as an incomplete truth always is. Claire Alderman, he explained to the jury, had received government assistance payments totaling $318,000 across 18 years under a program designated for licensed foster parents and certified legal guardians. The problem, the state argued, was straightforward. Claire Alderman's guardianship case had never been formally finalized. She had filed the initial paperwork. She had attended the required intake sessions. But the legal designation had never been completed. Not once. Not in 18 years. And therefore, every payment she had received during that period had been collected under false pretenses. He had a chart on the screen behind him, a clean white background timeline with dates and payment amounts arranged in neat rows that managed to make 18 years of another person's life look like a line-item audit. He had 2 witnesses from the County Social Services Department ready to testify, on official record, that the guardianship status had remained unresolved for the entire duration. The gallery took this in without sound. Claire's attorney wrote in small, precise script. Claire listened with her hands flat on the table and thought about how the same collection of facts can be assembled to produce almost any picture you want, depending entirely on which facts you include and which ones you quietly leave on the floor. What Fane's timeline did not include, what it had been constructed specifically to exclude, was the 18 months that preceded every single payment on that chart. 18 months during which Claire Alderman had done everything the county asked of her, submitted everything they requested, attended every meeting they scheduled, and received in return almost nothing except the promise that someone would get back to her. It began in the winter of the year she turned 54. She was working nights in the emergency department at Whitfield Regional Medical Center, a hospital that served the western half of Calverton County and operated in the permanent low-grade crisis of an institution that is always slightly under-resourced and has learned to function that way. She had been a nurse for 24 years by then. She knew that building the way you know a person you have lived alongside for decades, its habits, its failure points, the specific flicker of the overhead light in Bay 4, and exactly how long you had before it gave out entirely. She came off a double shift on a Tuesday morning when she heard about the boys from a caseworker named Phyllis Okafor, who ran the hospital's family advocacy office out of a room with 2 desks and a corkboard that hadn't been updated since the previous administration. Phyllis had the energy of someone who had been fighting the same battles for 20 years and had not yet decided to stop. She flagged the case for anyone willing to engage with it. 3 brothers. Ethan, 7. Noah, 5. Caleb, 3. Their mother had died of cardiac arrest 4 days earlier. Their father, a man named Gerald Rivers, had been arrested 2 weeks before her death on federal charges and was awaiting trial upstate. There were no in-state grandparents. No extended family had returned any of Phyllis's contact attempts. The boys were in emergency temporary foster placement, but the family hosting them had communicated clearly and with evident regret that they could not take them past the end of the month. Claire stood in the doorway of the advocacy office in her scrubs, with her hair still pinned from the shift, and said, "What happens to them if nobody steps in?" Phyllis looked at her with the exhaustion of someone who has answered that question more times than the question deserves. "The system," she said. "They get absorbed and we hope it goes well." Claire was quiet for a moment. Then, "What do I need to file first?" "Claire, which form? I want to start today." Phyllis had looked at her for a long moment. Then she'd opened her bottom desk drawer. Claire met the boys later that afternoon in a corridor outside the temporary placement office. Ethan was seated in a plastic chair with both arms wrapped around his youngest brother, who had gone to sleep against his side with one hand fisted in the fabric of Ethan's shirt. Noah sat cross-legged on the floor nearby, holding a picture book with the pages facing away from the door, which Claire suspected was intentional. He didn't want to be caught waiting. She crouched down to Ethan's level and kept her hand still, and said, "My name is Claire. I work in this building. I have a house in Fenwick Park with 2 extra bedrooms and a yard with a fence. I'd like you 3 to come stay with me while things get sorted out." Ethan studied her, not with the blank wariness of a child who has shut down, but with the measuring attention of one who has learned to assess quickly. "For how long?" he said. "I don't know the answer to that yet," she said. She had decided, standing in Phyllis's office, that she would not offer these children a timeline she couldn't guarantee. "But I'm not going to set one and walk away when it runs out." He held her gaze for a long moment, 7 years old with the stillness of someone twice that. Then he gave one short nod. "Okay." She drove them to Fenwick Park in her Subaru with the broken rear speaker that distorted everything slightly at higher volumes. Caleb slept through the entire ride. Noah pressed his face against the window and watched the streets go by without speaking. Ethan sat in the front. He'd asked, quietly, and she'd moved her bag, and watched the road ahead with the concentrated focus of someone memorizing a route in case they needed to find their way back alone. She made pasta for dinner because it was fast, and most children would eat it. She made up the 2 spare rooms with the bedding from the hall closet. She found a stuffed bear on the back shelf of Marcus's old room, her son, who had grown up and moved to Portland years ago, and set it on the dresser in Caleb's room without mentioning it. That night, after all 3 boys were asleep, she sat at her kitchen table with the paperwork Phyllis had given her and went through every page with a pen, a highlighter, and a legal pad for questions. She filed the forms by the end of that week, certified mail with return receipt. She called to confirm receipt. She attended the intake meeting. She submitted the follow-up documents they requested. Then she waited. Nothing moved. She called again. Her case was under review. She asked what the review entailed. She would be notified. She drove to the county social services building on a Thursday and waited in a plastic chair for an hour and 40 minutes before a clerk informed her that her file had been transferred to a different department. She drove to that department. The transfer hadn't processed yet. She asked when it would. The woman behind the desk said she had no way to estimate that. Claire drove home. She made dinner. She helped Noah with his reading worksheet. She sat in the doorway of Caleb's room until his breathing steadied into sleep. She came downstairs and called the county and left another message. This happened for 18 months. What she did not know, what no one with access to the information was going to tell her, was that her paperwork wasn't stalled because the county was slow. It was stalled because someone with access to the right system had made a decision that it should stay stalled. She would not learn that for another 18 years. She would not learn it until 3 men who had grown up in her spare bedrooms sat in a hotel room in this city and opened a file that was never supposed to surface. The afternoon session opened with Fane calling his first witness. Brenda Holt had been a caseworker with the County Social Services Department for 22 years and had been assigned to Claire's file in its 3rd year. She was slight, mid-50s, and wore her anxiety visibly. Hands too tightly folded, answers too short, the slight forward lean of someone bracing for something. She was not dishonest. Claire could see that clearly from the defense table. She was a person who knew one portion of a larger story and was being asked to narrate it as if it were the whole thing, and she didn't have the framework from where she was sitting to push back on that. Fane walked her through the timeline with patient, methodical precision. Each question built on the last. Each answer added another layer to the picture. By the end of the direct examination, he had assembled, from accurate facts, a portrait of systematic, long-running exploitation. The gallery had gone very quiet. Sasha's cross-examination started at a measured pace. "Ms. Holt, during your tenure as the assigned caseworker on my client's file, Did you at any point personally recommend that the guardianship be formally finalized? Brenda Holt's hand shifted in her lap. Yes, I made that recommendation. When, specifically? In the second year of my involvement with the case, third year of the case overall. What happened after you submitted that recommendation? It went to supervisor review. And what did supervisor review return to you? A pause, brief but audible in the stillness of the room. A notation, saying the case needed additional documentation before it could proceed. What documentation? The notation didn't specify. Did you request clarification? I submitted a request, yes. What did you receive in response? A reply that the review was still ongoing. Sasha lifted a folder from the table. County records show that your finalization recommendation was submitted with a complete supporting package, financial statements, a home environment assessment, educational records for all 3 children, and medical summaries. Is that accurate? Yes. And those same records show that 3 weeks after that submission, the case was returned to pending status with no explanation beyond the notation, additional review required, correct? Brenda Holt looked at the folder. She looked at the table. She looked briefly at Claire. Yes, she said quietly. That's correct. The murmur from the gallery was small, but it was real. Judge Merck touched the bench with one knuckle, and the room settled. Fain redirected without missing a beat, pulling Holt back to the official record of incomplete paperwork, returning to solid ground without appearing to retreat from it. He was skilled at this, the patient reestablishment of the version he needed the jury to hold. 2 of the jurors who had shifted slightly during cross-examination returned to their earlier postures. It wasn't enough. Not yet. But something in the surface of Fain's case had developed a hairline crack, and hairline cracks have a way of expanding under the right pressure. The 4:30 recess gave Claire 15 minutes in a small conference room with bad vending machine coffee, and Sasha across the table working through her notes with a pen that kept requiring extra pressure to write. Holt's testimony gave us something, Sasha said, not looking up. The jury heard that a finalization recommendation existed. They heard that it was returned without explanation. That's a different picture than this morning. It's not enough, Claire said. No, not on its own. Sasha set down the pen. I need to find what connected those supervisor reviews to something external. The pattern is too consistent for 18 years to be administrative backlog. Someone was making a decision every time the case got close to resolving. There's a reason it never resolved, Claire said. I just don't have the documentation to prove it from where I'm sitting. Sasha looked at her. But someone does. Claire wrapped both hands around the coffee cup. Ethan called me 2 nights ago. He said they were coming. I told him not to. Why? Because this is my problem. They have careers and responsibilities, and I didn't raise them to clean up after me. What did he say? The corner of Claire's mouth moved, barely perceptible, but there. He said I'd raised 3 people who apparently never learned how to walk away from something that was wrong. She looked at the table. He's not incorrect about that. Sasha studied her carefully. Who are they? What do they actually do? Ethan is a lieutenant colonel in the U.S. Army. Noah went to law school after his service and has been practicing federal litigation for 6 years. Caleb is in federal intelligence work, the specific nature of it. I'm not going to describe in detail, but he has clearances that go considerably higher than anything in this building. The room held the silence for a moment. They're coming tomorrow, Sasha said. It wasn't quite a question. They landed this afternoon, and they've been going through records. Since yesterday morning, Claire set the cup down. Noah called me an hour before court started today. He said they found something in the county archive records that explains why the supervisor reviews kept returning the case to pending. He said it connects to something outside the social services department entirely. Sasha was quiet. She picked up her pen and held it without writing. Why didn't you tell me this morning? Claire looked at her evenly. Because I needed to know you were fighting this case on its own merits, not on the assumption that outside help was arriving. If this case lives or dies on what 3 people found in a hotel room in Calverton, that's not a foundation I want to build on alone. Sasha absorbed that. Then she opened a fresh page on the legal pad. Tell me everything Noah told you. Outside the courthouse at 5:10, the November air was the kind of cold that doesn't apologize for itself. Claire stood on the stone steps while Sasha retrieved her document bag from her car, and the brass light fixtures above the entrance threw their gold circles across the pavement below. The photographer from the Ledger had packed up and gone. The Fenwick Park neighbors had dispersed. The parking lot held a scattering of cars belonging to people still working inside the building. She thought about the drive home, about whether the soup in her refrigerator had made it another day, or whether she'd be making something from what was left in the pantry, about whether she would sleep tonight. She already suspected she would not, but she had functioned on very little sleep before and knew how to manage it. Her phone buzzed. A text from Ethan. Hotel on Marsh Street. Noah has everything organized. He needs 2 hours with your attorney tonight. Can you make that happen? Not a question. She had raised him. She recognized the syntax. She typed back, I'll ask her. Are you all right? 3 seconds. We're good. We found what we needed. Then, after a pause of maybe 10 more seconds, a second message. You should have called us sooner, Mom. She stared at that word for a moment. He had started using it when he was 9 years old, in the second year she had him, on a Tuesday evening when she was helping him with a history project, and he had called her that without seeming to notice he'd done it. She had not corrected him. She had continued helping with the project and not said anything about it, and by the next morning they had both agreed, without discussing it, that this was simply how things were. She put the phone in her pocket. Across the lot, a light on the second floor of the courthouse went dark. Then another. The cleaning crew was working through the building from the top down, the way they always did. The city was doing the ordinary things cities do at the end of a day, indifferent to what had happened inside one of its buildings. Somewhere in this county's records, in a storage room or an archived server or a filing cabinet that had not been properly audited in years, there were documents that had been left to accumulate dust for 18 years. Notes from supervisor review sessions, records of decisions made behind closed doors that had shaped the official version of her case without her ever being told those decisions had been made. Communications between people who had never expected anyone to look for them. She had spent 18 years raising 3 children, working double shifts, filing paperwork, making phone calls, and driving to offices where people told her they would follow up and then did not follow up. And through all of it, she had never known that the obstruction was intentional. She had assumed the system was simply slow. She had given the people inside it the benefit of a doubt they had not earned and did not deserve. Tomorrow, the people who had built that obstruction were going to walk into a courtroom and discover that 3 people had spent the last 72 hours dismantling it from the outside. And the case that Douglas Fain had constructed so carefully, the clean timeline, the organized numbers, the portrait of systematic fraud built from carefully selected facts, was going to develop a great deal more than a hairline crack. Claire walked down the courthouse steps and crossed the parking lot to her car. She drove home through Calverton in the dark, through streets she had known for 19 years, past Whitfield Regional, where she had worked for 3 decades, past the elementary school where she had taken 3 boys to enrollment on a September morning and stood in line behind other parents and filled out forms, listing herself under the field that said guardian, because that was the truest word available, past the small park on Aldover Street where Caleb had learned to ride a bike on a Saturday afternoon, while Noah ran alongside him with one hand on the seat, and Ethan called instructions from the sidewalk, and all 3 of them were wrong about the technique, and none of them cared. She parked in her driveway. She sat with the engine off for a moment, listening to it tick as it cooled. Then she went inside, found that the soup was still good, ate it standing at the counter, and pulled the box from the hall closet, the one she had packed and repacked over 18 years, every letter, every receipt, every certified mail card, every case number written in her handwriting on the outside of every folder, and carried it to the kitchen table. She opened it. She began reading from the beginning. She was looking for the same thread Noah had found, but from her end. The place where the 2 lines would meet. The document or the date or the name that would show a jury not just that the process had failed, but that someone had made a deliberate choice to ensure it did. It was in here somewhere. She had always known, in the part of herself she didn't examine too closely, that the stalling had not been accidental. She had known it the way you know something you are not yet ready to act on, as a weight you carry without naming. She was ready to name it now. Outside, Calverton settled into its November night. The temperature dropped another 4 degrees. Somewhere across the city, in a hotel on Marsh Street, 3 men who had once slept in her spare bedrooms were awake under fluorescent light. going through the same records from the other direction, building toward the same point from the outside in. By morning, they would all arrive at the same place. And the people who had kept Claire Alderman in handcuffs were about to find out what happens when you underestimate the wrong woman for 18 years. The box held 47 folders. Claire had never counted them before. She had just kept adding to it over the years, sliding new documents into new folders, and pressing them in at the back and closing the lid and returning the box to the hall closet where it sat behind Marcus's old tennis racket and a bag of winter gear she kept meaning to sort through and never did. 47 folders across 18 years. She fanned them out across the kitchen table under the overhead light and looked at them the way she used to look at a patient chart when something wasn't adding up. Not searching for anything specific yet, just letting the whole picture settle before she started pulling at threads. The soup had gone cold while she was doing this. She didn't notice until she picked up the bowl again and the temperature registered as wrong. She set it back down and kept reading. The first folder held the original intake forms from the County Social Services Department, the ones Phyllis had walked her through on that Tuesday morning 19 years ago. The paper had yellowed slightly at the edges. Her own handwriting was there in the fields, in the careful block print she'd used for official documents since her military days, because cursive got misread under pressure, and she had learned early that clarity in paperwork saves lives just as surely as clarity in a trauma bay. She had answered every question. She had attached every supporting document Phyllis told her to attach. She had signed at the bottom with the date and her contact number and the address in Fenwick Park. She set it aside and moved to the second folder. Then the third. By the time she reached folder 11, which covered the period from month 14 to month 18 of the original filing process, she found what she had always registered as wrong without being able to name why. There were 4 letters in that folder from the county office, each one acknowledging receipt of materials she had submitted, and each one concluding with a version of the same phrase. Your case remains under active review and you will be contacted regarding next steps. She had read those letters at the time and understood them as bureaucratic delay. Now reading them in sequence on a kitchen table at 11:30 at night with the city quiet outside and everything she had learned in court today sitting in her chest like a stone, she read them differently. The letters were identical in structure. Same paragraph breaks, same language, same non-committal closing. Not similar. Identical. As though someone had a template and was running it on a schedule. She pulled out her legal pad and wrote down the dates. Month 14. Month 15. Month 16. Month 18. No letter in month 17. She went back through the folder twice to confirm. There was nothing from month 17. Not a letter, not a postcard, not a case number update. Just a gap of 4 weeks where the county had apparently said nothing at all, followed by the resumption of the template letters as though the gap had not occurred. She wrote month 17, nothing on the legal pad, and circled it. Then she went to folder 12. At the hotel on Marsh Street, Noah Rivers had 3 laptops open on the desk and a room service tray pushed to the far corner that held the remains of something he had ordered at 7 and eaten approximately half of before forgetting it existed. He was 38 years old, lean in the way of someone who moved constantly rather than someone who exercised deliberately, with the particular focused quality of a person who had been in rooms where the stakes were high enough that inattention had consequences. He had that quality because he had been in those rooms. He had been a JAG officer for 4 years before transitioning to federal litigation, and the habits of both had compounded into something that made him very difficult to rattle and very effective at finding the thing other people didn't see. Ethan sat on the edge of the bed with his jacket off, his sleeves rolled to the elbow, going through a printed stack of county archive records that Noah had obtained through a contact at the state attorney's office that morning. Ethan was 41, broad-shouldered, with a stillness that people who didn't know him sometimes read as detachment, and that people who did know him understood was something else entirely. He had been in command positions long enough that stillness had become his natural register, the thing his body did when his mind was working at full capacity. Caleb was on the phone in the bathroom with the door halfway open, speaking in a voice low enough that the words were indistinct. He was 36, the youngest, and he had the particular quality of someone who had spent years in environments where being noticed was a liability. He moved quietly, took up minimal space in a room, and had a memory for detail that both his brothers had found alternately useful and unsettling since childhood. Noah pulled up a scanned document on the center laptop and leaned back in his chair. Ethan. Ethan looked up. Month 17, Noah said. Look at this. Ethan crossed the room and looked at the screen. The document was a county internal memo dated from the month that had no corresponding letter in Claire's files. It was addressed to the Supervisor Review Board, and it came from the office of a man named Gerald Pratt, who had been the Deputy Director of the County Housing and Social Services Coordination Office at the time. The memo had 2 paragraphs. The first paragraph described a meeting that had taken place with representatives from a private development company called Harwick Meridian Group regarding the residential areas in the western section of Calverton County. The second paragraph, in language that was careful enough to be deniable, directed the Supervisor Review Board to flag any pending guardianship or foster placement cases in those residential areas for extended review pending outcome of the coordination discussions. The residential areas named in the memo included Fenwick Park. Ethan read it twice, then he straightened up. That's the month. That's the month, Noah said. That's when the stalling became a policy instead of a backlog. From the bathroom, Caleb's voice went quiet for a moment. Then he came out with his phone at his side. I need both of you to hear this, he said. He sat down on the edge of the desk and looked at them. I've been on with a contact who has access to Harwick Meridian Group's federal filing history. As of 3 years ago, Harwick Meridian Group is a subsidiary of a holding company called Oren Capital Development. He paused. Oren Capital has 2 named partners on its formation documents. One of them is a real estate attorney named Dennis Pratt. He looked at Noah. Gerald Pratt's son. The room held that for a moment. So the deputy director, Ethan said slowly, flagged Claire's case for extended review while his son's company was in discussions with the county about developing the same neighborhood. And 18 years later, Noah said, that same guardianship case is the mechanism being used to prosecute her for fraud. Caleb nodded. There's more. Oren Capital filed a development application for the Fenwick Park District 4 years ago. It stalled. Community pushback, a few legal challenges from residents. The application is still pending. He looked at the door as though the corridor beyond it held something relevant. If Fenwick Park's long-term residents are discredited or displaced, the community opposition loses its anchor. The 3 of them were quiet. Noah turned back to his laptop. Then this isn't just about the money, he said. The prosecution isn't about recovering fraudulent payments. It's about removing Claire from the picture at exactly the moment she's most useful to the opposition against the development. Who's the prosecutor? Caleb asked. Douglas Fain, Ethan said. Caleb pulled something up on his phone. He read for approximately 20 seconds. Then he set the phone face down on the desk with the precise, controlled movement of someone who has just confirmed something they were hoping they were wrong about. Fain's wife sits on the board of a charitable foundation that received a $200,000 donation from Oren Capital Developments 14 months ago, he said, 3 months before the charges against Claire were filed. Nobody said anything for a moment. Then Noah picked up his phone and called Sasha Brend. Sasha arrived at the hotel at 12:40 in the morning with her document bag over one shoulder and the particular expression of someone who has been awake for 19 hours and has just been told the reason they need to stay awake for several more. Noah met her at the door. She walked in, looked at the 3 laptops and the spread of documents and the 2 men she had not previously met, and said, "Show me everything in chronological order. Don't summarize. I'll tell you what matters." Noah showed her. It took 2 hours and 20 minutes. Sasha asked questions that were short and specific and wrote continuously on her legal pad while Noah walked her through the document chain. She asked Ethan twice to clarify the chain of custody on the archive memo, how it had been obtained, by whom, through what official channel, and each time he answered in precise, unhurried detail. Caleb sat to one side and provided the financial connection documentation when she reached that portion of the timeline, pulling up the original filings on his laptop and rotating the screen so she could read them directly rather than through his summary. At 3:05 in the morning, Sasha closed her legal pad. She pressed both hands flat on the cover of it and looked at the table for a moment. "This is enough," she said. "Not comfortable enough. Not as tight as I'd want it. But it's enough to get in front of the judge tomorrow and demand an evidentiary hearing, and once we're in that hearing, this unravels." She looked at Noah. "I need your bar admission status in this state." "I'm licensed in 3 states. This is one of them." Then I'm filing an emergency motion tonight to add you as co-counsel. She looked at Ethan and Caleb. You two are witnesses. I need written statements from both of you before 7 this morning, describing exactly how and when you obtained each document. Don't editorialize, don't characterize, just what you did and when. Understood, Ethan said. She stood up and put her legal pad back in her bag. At the door, she stopped without turning around. Has Claire seen any of this? Not yet, Noah said. She told us not to call her until morning. Sasha nodded once. She's going to be steady when you show her, she said. I've been sitting next to her for 2 days, and I don't think I've seen the woman flinch at anything. She opened the door. I'll see you at the courthouse. Claire found the second thread at 1:47 in the morning. It was in folder 23, which covered the 6th year of the case. 3 years after Brenda Holt had submitted her finalization recommendation and had it returned without explanation. There was a letter in that folder from a different caseworker, a man named Terry Owusu, who had been assigned to the case during a departmental transition period. The letter was addressed to Claire and informed her that her case had been assigned a new reference number following a system-wide administrative restructure. The new number was printed at the top. She had filed it at the time without thinking much about it because case number changes during restructures were not unusual, but the original case number was still on the letter, printed directly above the new one. She looked at the original number. Then she flipped back through folder 2, which held the initial confirmation of receipt from the county. She found the original case number there. They didn't match. She looked at both numbers for a long time, long enough that the kitchen went very quiet around her, and she became aware of the refrigerator cycling on in the way you become aware of a sound when everything else drops away. The number on the restructure letter was not a new number assigned to her existing case. It was a different number entirely, which meant at some point between folder 2 and folder 23, her original case had been closed, not finalized, not resolved, just closed, and a new case had been opened in its place, and the new case had started its clock from 0. That was why the process had never completed. It had been reset, quietly. During an administrative restructure that gave someone the cover to do it, without it appearing deliberate, her case had been erased and started over. 18 years of payments made while a case that was perpetually starting from 0 would never, by design, reach a conclusion. She sat back in her chair. Outside, a car passed on the street. Its headlights swept briefly across the kitchen wall and disappeared. She pulled the legal pad toward her and wrote down both case numbers. Then she wrote case closed and reopened, year 6, administrative restructure, and underlined it twice. Then she sat and looked at what she had written and thought about the specific quality of a trap that is built so gradually, so incrementally, that the person inside it only sees the walls when they finally stop moving. She had kept every document they had ever sent her. She had kept them out of habit, out of the military-trained instinct that paperwork is protection, out of a quiet stubbornness she had never fully examined. She had not known, when she filed folder after folder in this box over 18 years, that she was building the evidence of her own defense. She picked up her phone and called Noah. He answered on the second ring, which told her he hadn't been sleeping either. I found something, she said. So did we, he said. Mom, we found a lot. She heard the controlled steadiness in his voice and recognized it as the same quality she had tried to model for all 3 of them when they were young, and something had gone wrong and panic was not going to help. He had absorbed it completely. They all had. Tell me, she said. He told her. She listened without interrupting. She sat at her kitchen table with the 47 folders spread around her and listened to her youngest son's voice describe 18 years of deliberate obstruction, the memo, the development company, the financial connection to the prosecutor's household, the case number reset, all of it laid out in the careful sequential order of someone who had been trained to present evidence to people who needed to understand it quickly and completely. When he finished, the kitchen was very quiet. Claire, he said. He only used her name when he was being precise about something. This goes past the social services department. This goes past the supervisor review board. Fain knew what this case was built on before he filed it. I know, she said. He prosecuted you knowing the underlying paperwork had been manipulated. I know. A pause. Are you all right? She looked at the spread of folders on the table. 18 years of paper, 18 years of certified mail and case numbers and letters from officials who had promised follow-up they had never intended to provide. 3 boys she had fed and housed and driven to school and helped with homework and sat beside in hospital waiting rooms and watched grow into people she was more proud of than she had words for. And somewhere underneath all of it, a web of deliberate choices made by people who had calculated that she was too small, too ordinary, too unlikely to have backup, that she would accept what was being done to her because she had no mechanism to fight it. They had miscalculated on every point. "I'm fine," she said. "Sasha is filing an emergency motion tonight," Noah said. "She needs you at the courthouse by 8. She wants to walk you through what we're submitting before Fain sees it." "I'll be there at 7:30, Claire said. "You should sleep." "I'll sleep when this is over." Another pause. Shorter this time. "Okay," he said. 7:30. She put the phone down. She sat for a moment longer with the folders and the legal pad and the cold soup and the quiet house. Then she began repacking the folders in order. Not the order she'd pulled them out, but a new order. The order in which the story they told made the most sense when read from beginning to end. The order that showed not an old woman who had exploited a program for 18 years, but a woman who had done everything right while a system quietly worked against her. While people in offices she would never visit made decisions and meetings she was never told about, while a development company and a county official and a prosecutor built a trap out of her own compliance and her own paperwork and her own meticulous 18-year record of trying to do things correctly. She had the box repacked and relabeled by 3 in the morning. She made herself a cup of tea she didn't particularly want and sat with it at the table and thought about tomorrow. By the time the courthouse opened its doors, Fain would have received a copy of Sasha's emergency motion. He would read it. He would understand immediately what it contained and what it meant for his case. And for the first time since the charges had been filed, Douglas Fain would walk into a courtroom not as the architect of a controlled narrative, but as a man whose exposure was beginning. Claire had spent 2 days watching him perform certainty. She was familiar with that performance. She had seen it before in operating rooms, in command tents, in any environment where someone has decided that confidence displayed loudly enough substitutes for being right. She had watched those performances collapse under pressure enough times to know exactly what they looked like from the outside in the moment before the collapse. Tomorrow she would watch it again. She finished the tea. She rinsed the cup. She turned off the kitchen light and went upstairs. She lay down without undressing, set an alarm for 6, and closed her eyes. She did not sleep for a long time, but when sleep came it was solid and dreamless, the sleep of a person who has finally stopped waiting for something and started moving toward it. At 6:47 the next morning, she walked into the courthouse 14 minutes ahead of schedule, carrying the box from the hall closet and a cup of coffee she had made at home because she was not going to face whatever was about to happen in that building on vending machine coffee again. Sasha was already in the conference room with Noah beside her, both of them looking at a document on the table between them with the focused intensity of 2 people who have found the sentence that changes everything. Sasha looked up when Claire came in. She looked at the box under Claire's arm. "What's in there?" she asked. "Month 17, Claire said, "and a case number that doesn't match." Noah looked at his mother and said nothing for a moment. Then he pulled out the chair beside him. Claire set the box on the table. She sat down. She opened the lid. And 30 feet down the corridor in the main hall of Calverton County Courthouse, Douglas Fain walked through the front entrance with his leather portfolio under his arm, and his expression arranged in the particular configuration of a man who is already composing his opening remarks and has not yet read what is waiting for him at the clerk's office. He would read it in 4 minutes. Whatever arrangement his face had been holding would not survive the next 30 seconds after that. The clerk's office opened at 7:15 and the motion was already in the intake system by the time the first staff member unlocked the door. Sasha had filed it electronically at 4:22 in the morning. An emergency motion for evidentiary hearing, 41 pages including exhibits, submitted under the procedural provision that allowed emergency filings in active criminal cases when newly discovered evidence materially affected the integrity of the proceedings. She had been precise about the language because the language mattered. Not newly discovered evidence that helped the defense, evidence that materially affected the integrity of the proceedings. That framing put the obligation on the court, rather than positioning it as a request from a defendant who was losing. Noah had reviewed the final draft at 3:58 and changed 2 sentences. Sasha had accepted both changes without argument, which was not something she did reflexively. She had simply read his revisions and recognized that he was right. The motion cited 7 exhibits: the Pratt memo, the Harwick Meridian Group coordination records, the Oren Capital formation documents naming Dennis Pratt, the Charitable Foundation donation records connecting Fain's household to Oren Capital, the original case number from Claire's intake confirmation, the restructure letter carrying the replacement number, and a signed declaration from Caleb Rivers describing the federal filing history he had accessed through official channels, with his clearance level and federal service record attached as a separate document, 41 pages, 7 exhibits, filed at 4:22 in the morning by a woman who had been awake for 22 hours and whose handwriting on the cover sheet was as clean and level as if she'd written it at noon on Arrested Tuesday. Douglas Fain read it at 7:51 in the lobby of the courthouse, standing beside a marble pillar with his leather portfolio open and his phone pressed to his ear. Claire watched him from the corridor window of the conference room, 30 feet away and 1 floor up, through glass that muted whatever conversation he was having into inaudible movement. She watched his face go through 3 distinct changes in the space of 90 seconds. The first was confusion, a genuine, unperformed confusion, the expression of someone encountering information that doesn't fit the structure they were operating inside. The second was the specific stillness that follows confusion when the brain is processing something it doesn't want to confirm. The third was harder to name. Not fear exactly, but the thing that lives adjacent to it in a person who has been certain for a long time and has just been handed a reason to stop being certain. He closed the portfolio. He ended the call. He stood beside the pillar for a moment with his hand still holding the phone against his side, not moving, the way people stand when they are running a calculation they didn't expect to need. Then he walked toward the elevator. Claire turned away from the window. "He's read it," she said. Sasha looked up from the table. "How does he look?" "Like a man who just found out the house he built has a problem with the foundation." Noah was already gathering documents into a structured order, the mechanical efficiency of someone channeling adrenaline into preparation. Across the table, Ethan sat with both hands flat on the surface and watched his brother work without offering to help, which meant he had already done what he could do and understood that the next phase belonged to someone else. Caleb was on his phone again, in the chair by the window, speaking in the same low, half-audible register he'd used the previous night. Claire set her coffee down and opened the box. "Walk me through the case number evidence one more time," she said to Sasha. "I want to know exactly how you're going to present it." "The original intake confirmation carries case number 04GFC2271, Sasha said. "The restructure letter from year 6 carries case number 04GFC3849. 2 different numbers means 2 different case files in the county system. A case file that closes resets the clock on every obligation attached to it, every timeline, every processing deadline, every procedural requirement. If the original case was administratively closed during the restructure and a new one opened in its place, then from the system's perspective, the guardianship process never exceeded 6 years. It was never flagged for escalation. It was never automatically elevated to a director-level review, which is triggered at the 8-year mark." She paused. "The 8-year trigger would have forced a resolution. Closing and reopening the case before that threshold ensured the trigger was never reached." "Can you prove the closure was deliberate?" Claire asked. "I can prove it was structurally convenient for people who had a financial interest in the case, remaining unresolved. A jury doesn't need mathematical certainty. They need a reason to doubt the prosecution's version." "Fain will argue it was administrative error," Noah said, without looking up from the documents. "He can argue that," Sasha said, "and then I'll ask him to explain the Pratt memo, the Oren Capital connection, and the $200,000 donation to his wife's foundation." She said it without heat, with the flat delivery of someone stating a sequence of steps rather than making a threat. "He's welcome to call all of it coincidence. Juries tend to have opinions about coincidence." Judge Roland Merck entered his chambers at 8:20 and found the motion on his desk with a note from his clerk that both parties had been notified of an emergency hearing at 9 a.m. He read the motion in 12 minutes. His clerk, a woman named Dana Ferris, who had worked with 3 different judges over 15 years and had a precise sense of what she was and was not supposed to visibly react to, watched him read it from her desk in the anteroom and did not react visibly to the way his expression changed on page 11 and did not recover. He called his clerk in at 8:34. "Has Fain acknowledged the hearing notice?" he asked. "His office confirmed at 8:17, she said. "Anyone else been notified?" Dana Ferris paused for exactly the length of time it takes a careful person to decide how to answer a question they understand the weight of. "The motion references a federal service declaration from a Caleb Rivers," she said. "My understanding is that the filing triggered an automatic notification to the federal agency listed on the declaration. Standard procedure when active federal personnel are named in state court documents." Merck looked at her. "Standard procedure," she said again, evenly. He looked back at the motion. "Thank you, Dana." She returned to her desk and did not mention that the notification had gone out at 4:23 in the morning, 1 minute after the motion hit the system, and that the acknowledgement from the federal agency had come back in 11 minutes, which was not standard in her experience, and which she had been thinking about since she'd arrived at the office an hour ago. The courtroom at 9 Handcuffs was different from the courtroom of the previous 2 days. The difference was not immediately obvious. The same benches, the same overhead lights, the same configuration of tables and chairs, and the elevated bench where Merck settled himself with the motion open in front of him. But the gallery had more people in it than the previous sessions had drawn. Word had moved through the courthouse in the way that significant developments move through institutional buildings, person to person, in the 40 minutes between the filing notification going out and the hearing starting. There were faces Claire didn't recognize in the back rows, a man in a suit she hadn't seen before sitting apart from the reporters, and in the row behind the Fenwick Park neighbors, 3 people whose presence she registered and then carefully did not look at again. Ethan, Noah, Caleb. They had taken seats in the gallery rather than at the defense table. Noah would join Sasha at the table when Merck acknowledged his co-counsel status, but for now they were in the gallery, in civilian clothes, sitting with the particular quality of stillness that people develop when they have been trained to occupy space without drawing attention to themselves and have spent years practicing. They were very good at it. Claire had watched them develop that quality from the beginning, each in his own way, and it still struck her sometimes how completely it had become part of them. Fain was at the prosecution table with a man Claire didn't recognize, younger, maybe 35, with the look of someone who had been pulled in on short notice and was still processing the situation. They were speaking in voices too low to carry. Fain's leather portfolio was open on the table, but he wasn't looking at it. He was looking at the motion, a physical copy of which he had apparently printed and annotated. She could see handwriting in the margins from across the room. Merck called the room to order. "I've reviewed the emergency motion filed by the defense at 4:22 this morning," he said. "I'm going to hear argument from both parties before I make any procedural determination. Ms. Brend, this is your motion. You have the floor." Sasha stood. She had changed into a different suit from the previous 2 days, charcoal gray, clean lines, and she carried herself with the ease of someone who has done the work and is not afraid of the examination. She walked the judge through the motion exhibit by exhibit, without rushing, without editorializing, presenting each piece of evidence in the sequence that made its significance clearest. She was good at this. Claire had known she was good at this from the first meeting, but watching her now in front of a judge who was clearly troubled by what he was hearing, she understood that Sasha Brend was the particular kind of attorney who gets better as the stakes get higher. She spent 11 minutes on the Pratt memo and its connection to the Harwick Meridian Group coordination discussions. She spent 8 minutes on the Oren Capital Formation documents and the relationship between Gerald Pratt and Dennis Pratt. She spent 6 minutes on the case number, discrepancy, and its procedural implications. And then she paused, turned one page in her notes, and said, "Your Honor, I would now like to address the relationship between the prosecuting attorney and Oren Capital Developments." Fain was on his feet. "Objection. Counsel is introducing allegations against a member of the bar without foundation." "Sit down, Mr. Fain," Merck said. The room absorbed this. Fain sat. Sasha placed the charitable foundation records on the document presenter. The numbers appeared on the screen. The donation amount, the date, the name of the receiving foundation, the board member list with Fain's wife's name third from the top. She did not editorialize. She read the numbers and the dates and the names in the same flat, precise voice she had used for everything else, and let the sequence speak for itself. When she finished, the courtroom was the quietest it had been in 3 days. Merck looked at Fain. Counselor. Response. Fane stood. He was controlled. She had to give him that. Whatever the motion had done to his internal landscape in the lobby an hour ago, he had assembled something functional over it. Your Honor, the defense has presented a collection of documents that establish, at most, a series of circumstantial relationships between parties connected to the county's historical administrative processes. There is no direct evidence that any of these relationships influenced the filing of charges against the defendant, and the implication that this office engaged in prosecutorial misconduct based on a charitable donation to a foundation on which my wife serves in a volunteer capacity is bull. Is the donation amount accurate? Merck asked. A pause. I would need to verify. Is the foundation correctly named in these documents? Another pause, shorter but visible. The foundation name appears to be accurate, Your Honor, but the suggestion that, is your wife listed as a board member? Fane stopped. The courtroom did not move. Mr. Fane, Merck said, in a voice that had dropped half a register from where it had started. I'm going to ask you a direct question, and I want a direct answer. Were you aware of any financial relationship between Orin Capital Developments and any foundation or organization associated with your household at the time you filed charges in this case? The pause this time was long enough that it became its own answer. Your Honor, that's a yes or no question. Fane looked at his co-counsel, then at the table, then at a point somewhere between the table and the front of the room. I was aware of the donation, Your Honor, but I did not consider it relevant given the arm's-length nature. Thank you, Merck said. He looked down at the motion. He was quiet for a moment. Then he said, We're going to recess for 1 hour. Both parties will remain available. I'm going to make several calls. He stood. The bailiff called the room to order for his exit. Merck walked toward his chambers without looking at either table, and for the first time in 3 days, he looked like a man who understood that his day was not going to proceed according to his expectations. The recess lasted 40 minutes instead of an hour. In that time, 3 things happened that Claire was told about secondhand, and 1 thing she witnessed directly. Noah was formally acknowledged as co-counsel and took his seat at the defense table beside Sasha, which meant that when the gallery watched the defendant's side of the room, they were looking at a retired nurse, a 19-year litigation attorney, and a federal attorney with a JAG background, and the configuration of that table looked different from the configuration it had held for the previous 2 days. Fane's co-counsel left the courtroom during the recess and did not return, which Caleb, still in the gallery, noted and passed by text to Noah, who read it without changing his expression. And at some point during the recess, a man Claire did not recognize walked into the courtroom and took a seat in the back row, on the aisle, in the specific position of someone who wants an unobstructed line of sight to the front and intends to leave quickly if necessary. He was wearing a dark jacket and carrying nothing. He did not speak to anyone. Caleb looked at him once from 3 rows forward and then looked back at the front of the room, and something in the way he did it, the specific quality of the recognition, told Claire that the man's presence was not a surprise to her youngest son. She did not ask about it during the recess. She filed it. When Merck returned, he came in differently than he had come in before. Not slower exactly, but with less of the settled certainty that had characterized his entries on the previous days. He took his seat and looked at both tables and then looked at his notes and said, I've reviewed the procedural implications of the defense's motion, and I've consulted with the state attorney's office regarding the conduct concerns raised therein. Effective immediately, this hearing is suspended pending a formal review of the evidentiary foundation underlying the charges as filed. He looked at Fane. The state's case is stayed. The defendant's restrictions are modified. Ms. Alderman, your travel limitations are lifted as of this moment pending the outcome of the review. He paused. I am also referring the matters raised in Exhibits 4 and 5 to the county's Judicial Oversight Board for independent evaluation. Exhibits 4 and 5 were the Orin Capital formation documents and the charitable foundation donation records. The gallery erupted. Not loudly. It was a courtroom, and the instinct for decorum held, but the sound was real. A collective exhale and repositioning, the sound of a room full of people absorbing a shift they hadn't fully anticipated, even as they'd been watching it build. Fane sat at his table without moving. He had his hands folded on the surface, and he was looking at a point approximately 18 inches in front of them. Claire sat very still. Sasha leaned over and said, in a voice below the gallery noise. "This isn't the end. It's the beginning of the end. Don't mistake the two." "I know the difference," Claire said. At the defense table, Noah was writing. He had been writing since Merck began speaking. Claire glanced at the pad and saw that he was already drafting the next motion, not waiting for the dust to settle, moving immediately into the next procedural moment, the way she had once moved through a casualty scenario without stopping to process the one she'd just left, because the next one was already in front of her. He had learned that from somewhere. She looked away. In the gallery, Ethan was watching the front of the room with the same focused, measuring attention he had brought to every situation since he was 7 years old in a plastic chair outside a caseworker's office with his brothers. He was running the same calculation he always ran. What comes next? What needs to happen? What is the gap between where we are and where we need to be? She knew this about him the way she knew the sound of the Subaru's engine when it was running cold. She had been reading him for 34 years. Caleb was already on his phone, quietly, angled away from the row behind him. The man in the dark jacket in the back row had not moved. The courtroom cleared slowly after Merck's exit, not in the quick, purposeful way of a room dismissed for lunch, but with the gradual, uncertain movement of people who aren't sure the thing they witnessed is fully resolved and don't want to step away before it is. The reporters left first, which was its own information. They had what they needed and somewhere to be. The Fenwick Park neighbors left in a cluster, talking in low voices, Margaret Boyle's hand briefly on Donna Fitch's arm. Patricia Holm paused at the end of the row and looked at Claire across the room for a moment, a long, unreadable look, and then walked out without speaking. Claire was gathering the documents from the table when she heard footsteps behind her and turned to find Ethan and Caleb coming through the gallery rail. Ethan stopped in front of her and didn't say anything for a moment. She looked at him. The uniform he wasn't wearing today, the particular set of his face that he'd had since he was small, when something was happening that he didn't have words for. "You should have called us sooner," he said. The same thing he'd said by text. He needed to say it in person. "I handled what I could handle," she said. "That's not the point." "I know it's not." She picked up the box. "The point is you came anyway." He looked at her for another moment. Then he took the box out of her hands. She let him take it, which was its own statement. Caleb was beside her now. "We're not done," he said quietly. Not a warning exactly, more an orientation. "The Oversight Board referral is going to take time. Fane's people are going to move to contain this in the next 48 hours. Whatever they conceal, limit, or characterize as internal process, they're going to try." "What do we need?" she asked. "We need the original case file from the county archive," Caleb said. "Not the copy in Fane's discovery materials. The original, with the access logs showing who pulled it and when. Can you get that? Noah is filing for it in the next hour. Whether the county produces it voluntarily or we get a court order depends on how cooperative they decide to be." "They won't be cooperative," Claire said. "No," Caleb agreed. "They won't." Noah appeared from the direction of the clerk's desk, his legal pad under his arm and his phone in his hand. "Oversight Board has acknowledged the referral," he said. "They're assigning an independent examiner. I know the examiner. She worked the Delverton case 2 years ago. She's thorough." He looked at Claire. "She's also going to want to speak with you directly. Your account of the 18 months before the first payment is going to matter more than any document we have." "I can do that," Claire said. "I know you can." He said it simply, without the cushioning that people sometimes put around statements of confidence in someone else. Just the fact, stated. The courtroom was nearly empty now. A clerk was collecting materials at the prosecution table. Fane's leather portfolio was still there, which meant he had left without it. Not something a man who was in control of his situation does. The annotated copy of the motion was still open on the table, and from where she was standing, Claire could see the handwriting in the margins without being able to read it, dark and compressed, the handwriting of someone working very quickly through something. She looked at it for a moment. Then she turned away. They were moving toward the side exit when Caleb's phone vibrated. He looked at the screen and stopped walking. "What?" Ethan said. Caleb looked up. He had a specific quality when something had shifted that Claire had learned to recognize. Not alarm, not even urgency, but a recalibration. The look of someone adjusting their operating picture. "The man in the back row," he said. He's not oversight. Who is he? Noah asked. Caleb looked at Claire, then back at his phone, then at Ethan. Gerald Pratt died 14 months ago, he said. Natural causes. His son Dennis took over Orin Capital as sole operating partner. He paused. Dennis Pratt's personal attorney filed an emergency injunction 40 minutes ago in federal district court to seal the Orin Capital formation documents. The corridor outside the courtroom was quiet. A water fountain ran somewhere down the hall. He's trying to pull the documents before the oversight board can examine them, Noah said. Can he do that? Ethan asked. In federal court? With the right judge? In the next 12 hours? Noah's voice was level. Maybe. Caleb was already typing. The man in the back row is Dennis Pratt's legal attaché. He's been in that seat since the hearing started. He wasn't watching the case. He put the phone in his pocket. He was watching us. Claire stood in the corridor outside the courtroom with her 3 sons around her and the sounds of the courthouse moving through the building. Footsteps, a distant phone, the particular institutional hum of a building that processes consequences for a living. And she thought about what Caleb had just said with the specific, focused clarity of a person who has learned to think most precisely when the situation is moving fastest. If the formation documents were sealed before the oversight board examined them, the direct link between Orin Capital, the Pratt family, and the manipulation of her case would be buried in federal process for months, maybe longer. Fain's conduct referral would proceed, but without the financial chain behind it, it became a much smaller story. A prosecutor who failed to disclose a conflict of interest rather than a prosecutor who knowingly brought charges as part of a coordinated effort to silence a community opponent. 2 different cases, 2 very different outcomes. How long do we have? She asked. Noah calculated. The federal injunction was filed 40 minutes ago. Emergency hearing on an injunction of this type takes between 4 and 8 hours to schedule, depending on docket. If we file a counter-opposition in the next 90 minutes, we get standing to appear at that hearing. Do it, Claire said. I'm already writing it, he said. She looked at Caleb. The access logs for the county archive file. Can we get them faster than a court order? Caleb looked at her carefully. Define faster. Today. He was quiet for 3 seconds. I'll make a call. Make it. He stepped away down the corridor with his phone already at his ear. Ethan was watching Claire. She could feel it without looking at him. The weight of his attention, the particular way he had of observing her when something was happening that he wanted to understand completely. You've been 2 steps ahead of this since before we got here, he said. It wasn't an accusation, it was an observation, and underneath it was something she recognized as the tone he used when he was recalibrating something he thought he already knew. She looked at him. I've been watching people underestimate me for 73 years, she said. At some point you stop reacting to it and start using it. He held her gaze for a moment. Then something shifted in his face, not quite a smile, but the thing that exists in the same territory. Yeah, he said quietly. I know where we learned that. Down the corridor, Caleb's voice was low and rapid and entirely inaudible. Outside the courthouse, the November morning had given up on gray and settled into a hard, clear cold. The kind of cold that makes everything look more defined than it actually is. Somewhere across the city, in a federal courthouse, a filing had just landed on a clerk's desk that had the potential to undo everything that had happened in the last 3 hours. And in an archive room in the Calverton County Administrative Building, a file cabinet held a folder with a chain of access entries going back 18 years. Entries that showed who had touched the case, and when, and in what sequence. And that file cabinet had not been opened in 11 months, and the person who last opened it had not expected anyone to ask about it. They had 40 minutes before Fain's people figured out what Caleb was looking for. Possibly less. Caleb was on the phone for 4 minutes and 30 seconds. Claire counted without meaning to. The old habit of measuring time in pressure situations, a reflex so deeply embedded she no longer noticed she was doing it until she was already done. 4 minutes and 30 seconds in the corridor outside the courtroom, Ethan standing 3 feet to her left with the document box under his arm, Noah already moving toward the clerk's office at the far end of the hall, with his legal pad open and his phone in his other hand, composing the counter-opposition to the federal injunction while walking, which was something she had watched him do with homework at age 12 and apparently never stopped. Caleb ended the call and came back. 60 minutes, he said. Maybe less. My contact can access the archive request logs remotely, but she needs a formal records preservation order filed before she pulls anything, otherwise the documentation chain breaks and it's unusable in court. Noah, Claire called. He turned without stopping his forward motion, the particular skill of someone who has learned to do two things simultaneously without doing either badly. Records preservation order for the county archive. Case file access logs going back 19 years. Can you add it to what you're filing? Already adding it, he said, and turned back toward the clerk's office. Caleb watched his brother disappear around the corner. He's going to be exhausted for a week after this, he said. He'll manage, Claire said. I know. I'm just noting it. She looked at him. Caleb had always been the one who noted things. The temperature of a room, the subtext of a conversation, the detail that everyone else had moved past. He had been that way at 3 years old in the back seat of the Subaru, and he was that way now, and she had never decided whether she had shaped that quality in him, or whether it had simply been there from the start, and she had only provided the conditions for it to develop without being crushed. Your contact, she said, the one who can access the logs. Yes. Is she taking a risk doing this? He met her eyes. She's following procedure. The preservation order makes it clean. That's not what I asked. A pause. She's careful, he said. She knows what she's doing. It was not a complete answer, and they both knew it. Claire filed it in the same place she filed everything she couldn't address immediately and moved forward. The county archive building was 4 blocks from the courthouse, a 3-story concrete structure that had been built in the early 80s and had received no significant renovation since, which meant the filing systems on the first 2 floors were a hybrid of digitized records and physical folders that had been incompletely cross-referenced during a transition project that had apparently run out of funding before completion. Caleb knew this because his contact had told him, and his contact knew it because she had spent the last 6 hours going through the system structure while they were in court. The physical folder for Claire's case, the original, not the copy in Fane's discovery materials, was in a lateral filing cabinet on the 2nd floor, Drawer 7, under case number 04 GFC 2271. The original number, the one that predated the restructure. The digitized record in the county system carried only the replacement number, 04 GFC 3849, which meant that to anyone searching the system for Claire's case history, the original file did not appear to exist. It had never been destroyed. It had simply been made invisible by the act of removing its number from the searchable index and filing it in a drawer that no one had reason to open unless they already knew what they were looking for. The access log for that drawer showed 4 entries in the last 19 years. The first was the initial filing date. The second was 11 months after that, during the period when Phyllis Okafor had been actively working the case and had apparently come to the archive directly for something. The third was in month 17, the month with no letter. The fourth was 3 weeks before the charges against Claire had been filed. Caleb's contact sent him the log entries by secure message at 10:14. He read them standing in the courthouse lobby, his back to the wall, and then forwarded the message to Noah without commentary because the commentary was unnecessary. The third and fourth entries spoke for themselves. Month 17, the month Gerald Pratt's memo had redirected the supervisor review process. Someone had accessed the original file. And 3 weeks before Fane filed charges, someone had accessed it again. Both access entries carried the same employee identification number. The employee was no longer with the county. She had taken early retirement 8 months ago with a pension supplement that was, according to the HR records Caleb's contact had pulled alongside the access logs, 22% higher than her years of service would have generated under the standard formula. A pension supplement authorized by the Office of the Deputy Director of Housing and Social Services Coordination, Gerald Pratt's office. Noah filed the counter-opposition to the federal injunction at 10:31 and the records preservation order at 10:44. The federal court acknowledged the counter-opposition at 11:02 and scheduled the emergency hearing for 2 Asosha in the afternoon, which gave them 3 hours and meant they did not have the margin Caleb had originally estimated. The hearing would happen before anyone could pull the archive file if the preservation order was delayed. Sasha called at 11:15. The Oversight Board examiner has been assigned, she said. Her voice had the slightly flattened quality of someone speaking carefully because they are in a space where they might be overheard. Her name is Renata Voss. She's requesting a preliminary meeting with our team at 1 o'clock before the federal hearing. Where? Noah asked. He had taken the call on speaker in the small conference room they had reclaimed for the morning, all four of them around the table with documents spread between them and cups of coffee going cold at the edges. Her office is in the Mercer building on 5th. She's coming to us. She requested the courthouse specifically. Why? She didn't say. A pause. She also requested that Claire be present. Claire looked up from the access log printout she had been studying. I'll be there, she said. She knows about the federal hearing, Sasha said. She's aware of the injunction attempt. I don't know how, but she's been briefed on more than what's in our motion. Caleb set down his coffee. Someone briefed her, he said. Not to anyone in particular, just placing it. The man from the back row, Ethan said. Caleb nodded once. Claire looked between them. Explain. The legal attaché, Caleb said. Dennis Pratt's man. He watched the hearing and then filed the injunction 40 minutes after we walked out. That's a very fast response time, unless the injunction was already drafted before the hearing and they were waiting to see how far the motion went. He paused. If it was pre-drafted, someone gave Pratt's team advance warning that our motion existed. The filing went into the system at 4:22 in the morning, Sasha said through the phone. How many people had access to it before the courthouse opened? The electronic filing system is accessible to any party registered in the case, Noah said. Fain's office would have received an automated notification when the motion hit the queue. Fain's office called Pratt, Ethan said. Or Pratt's office monitors Fain's case filings directly, Caleb said, which would mean the relationship between them is more operational than we've been treating it. Claire set down the access log. It doesn't change what we do in the next 3 hours, she said. It changes how we understand the structure. But the work is the same. They looked at her. Noah, what do you need for the federal hearing? The archive file itself would be ideal. The access logs are strong circumstantial evidence, but the original documents in the file, whatever was in there when it was accessed in month 17, that's the direct evidence. Can we get someone to the archive building before 2 o'clock? The preservation order is filed, Caleb said. The county is legally obligated to hold the file. Whether we can compel them to produce it before the federal hearing without a separate court order is a different question. Write the request for expedited production, Claire said to Noah. File it now and let the county decide how cooperative they want to be. She stood up. I'm going to go speak with Renata Voss. Sasha's voice came through the phone. The meeting isn't until 1. I know. Claire was already reaching for her cardigan. But I want to walk through the courthouse before it fills up again. I need to think. She walked for 40 minutes through the building's corridors and twice through the main hall, past the directory board and the water fountain and the row of wooden benches outside the civil division offices, where 3 different people sat waiting with the particular inward focus of people who are there because something in their life has reached a point where a building like this became necessary. She thought about Gerald Pratt, who was dead, and his son Dennis, who had apparently inherited both his father's business and his father's relationship to the machinery of county governance. She thought about the employee who had accessed the archive file twice at critical moments and had retired on a supplemented pension that told its own story about what that access had cost and what it had bought. She thought about Douglas Fain, who had known, she was now certain he had known, that the case he was prosecuting had been built on an administrative structure that had been deliberately engineered to look like incompetence. She thought about the way damage accumulates in a life, not in dramatic events, but in the slow pressure of small decisions made by people who are confident they will never be accountable for them. The unsigned memo, the template letter, the case number that disappeared from a searchable index, the pension supplement approved by a man who needed a favor maintained, each thing small enough to explain away individually. Together, a machine. She had spent 18 years inside that machine without knowing it existed. She had spent those years assuming that the delays were the product of an overloaded system doing its inadequate best, and she had given the people running it a charity they had not earned because she had believed, without examining the belief, that incompetence was more likely than malice. She did not think that anymore. The anger that came with this recognition was not hot. It had never been hot in her experience. The deep anger, the kind that matters, ran cold and steady and did not require expression to be real. She had felt it twice before in her life at this particular intensity. Once in a field situation during her deployment, when she had understood what had been done to a unit she was supporting and why. Once at the bedside of a patient whose deterioration had been preventable and whose chart showed that 3 separate opportunities to intervene had been missed by people who were not paying adequate attention. Both times, the anger had functioned as a kind of fuel, cleaner than grief, more directional than outrage. It did not make her sharp in a brittle way. It made her precise. She was very precise right now. Renata Voss was 54 years old and had the build and bearing of someone who had been athletic in a serious way earlier in life and had maintained the posture without maintaining the regimen. She wore her gray-streaked hair pulled back, carried a leather briefcase that had seen significant use, and shook Claire's hand with the direct, assessing grip of someone who forms impressions quickly and adjusts them rarely. They met in the conference room at 1:05. Sasha was there. Noah was there. Ethan stood against the wall near the door in the particular configuration of a large person in a small room who was trying to take up appropriate rather than maximum space. Caleb was not there. He had stepped out 7 minutes before the meeting and had not come back in, which meant he was on a call that he had decided the rest of them did not need to be present for. Voss set her briefcase on the table and opened it without sitting down first, which was slightly unusual, and told Claire something about how she operated. "I've been briefed on the motion and the evidentiary material," she said. "I've also been briefed on the federal injunction and the counter-opposition. Before I tell you what the Oversight Board is doing, I want to ask Miss Alderman a question directly." "Go ahead," Claire said. "The 18 months before the first payment, the original filing period. You were told, at some point, to begin drawing from the assistance program while the guardianship process continued. Who told you that?" "A caseworker named Terry Owusu," Claire said. "He took over the file during a departmental transition in month 16. "Did he put it in writing?" "He sent a letter confirming the guidance. I have it in my records." "I need that letter." "I have it here." She reached into the box and pulled folder 12 and extracted the letter from the 3rd position. She slid it across the table. Voss read it. Her expression did not change significantly, but something around her eyes adjusted, a slight sharpening. "This letter is on county letterhead," she said. "Yes." "Signed by Terry Owusu." "Yes." "With a case reference number at the top." "Yes." Voss looked up. "The case reference number on this letter is 04GFC3849, the replacement number, not the original." Claire had not noticed that. She looked at Sasha, who was already reaching for the letter. "Which means," Voss said carefully, "that Terry Owusu sent this guidance letter using a case number that the system had already generated in replacement of the original, which means the case had already been administratively restructured before month 16, and Owusu was working from the replacement file when he provided this guidance." "He didn't know about the original file," Claire said. "Almost certainly not." Voss set the letter down. "But the people who restructured the case did, and whoever restructured it understood that by putting the guidance letter on the replacement file, they were creating a situation where Claire Alderman was receiving payments under a case designation that had been engineered to never complete its process, while the original file, the one that had been properly filed and should have reached the 8-year escalation trigger, sat in a cabinet with no number in the searchable system." She looked at Claire. "That's not administrative error. That's a constructed mechanism for generating the appearance of fraud." The room was quiet. "How long have you known that?" Sasha asked. "Since about 11 this morning," Voss said, "when I received a document from a federal contact I trust." She did not look at the door, but the implication was clear enough. "The Oversight Board is not investigating Ms. Alderman. As of this morning's briefing, the Oversight Board is investigating the county's Housing and Social Services Coordination Office for the period covering Gerald Pratt's tenure, and the State Bar is opening a conduct inquiry into Douglas Fain." Noah set down his pen. "The federal injunction," he said. "If the Oren Capital documents are sealed before the Oversight Board can examine them." "The Oversight Board is not subject to the federal injunction," Voss said. "The injunction covers public disclosure. It does not cover documents produced under a state oversight subpoena, which I filed this morning at 9:47. She closed her briefcase. "The documents are already in our possession." Sasha stared at her. "You filed a subpoena before the injunction was filed at 9:47, Voss said. "The injunction was filed at 10:02. 15 minutes. Voss had been 15 minutes ahead of Dennis Pratt's legal team. Sasha sat back in her chair and was quiet for a moment in the way of someone recalibrating how much they had understood about a situation versus how much had already been in motion around them. Claire looked at Voss. "How long has the board been watching this?" Voss met her eyes. "Long enough," she said. Which was not a complete answer, but it was an honest one, and Claire had learned to accept honest incompleteness over dishonest precision. The federal hearing at 2 lasted 51 minutes. The judge assigned to the emergency injunction hearing was a woman named Patricia Sowell, who had been on the federal bench for 11 years, and whose demeanor on the bench was one of extreme, almost performative patience that people who did not know her sometimes mistook for indifference, and that people who did know her understood was the way she listened when she was forming a conclusion she was not yet ready to express. Dennis Pratt's attorney, a tall man named Warren Geld, who had clearly been given the brief at short notice and was operating on preparation that showed the seams, argued that the Oren Capital formation documents contained proprietary business information whose public disclosure would cause irreparable commercial harm. He spent 18 minutes on this argument and never once addressed the specific content of the documents or their relationship to the underlying criminal case, which Judge Sowell noticed and allowed him to continue not addressing until he was finished. Noah presented the counter-opposition in 11 minutes. He connected the formation documents to the Pratt memo, the supervisor review manipulation, the case number restructure, and the access log entries in a sequence that was compressed enough to be manageable in the time available and complete enough that none of the connections could be dismissed as speculative without evidence. He did not editorialize. He did not characterize the opposition's motives. He simply showed the chain. Judge Sowell asked Geld one question. "Counsel, are you representing that your client was unaware of the county administrative proceedings described in the counter-opposition?" Geld said, "Your Honor, my client's connection to county administrative matters is—" "That's not what I asked," Sowell said. "I asked whether your client was unaware of them." Geld stopped. Sowell waited. "My client was aware of certain coordination discussions," Geld said finally, in the voice of a man who has just stepped onto ground he did not want to reach and cannot step back off. Sowell looked at him for a moment. Then she looked at her notes. "The injunction is denied," she said. "The documents remain accessible under the Oversight Board subpoena. I am also referring this filing to the federal bar for review of the conduct standards applicable to emergency injunction practice." She stood. "We're adjourned." Geld gathered his materials from the table with the efficiency of someone focused entirely on getting out of the room. He was on his phone before he reached the door. Noah stood at the table with his legal pad and looked at Claire, who was seated in the gallery 2 rows back. She gave him a single nod. He nodded back and started packing up. By 4 o'clock that afternoon, 3 things had been set into irrevocable motion. The State Bar had opened a formal conduct inquiry into Douglas Fain, which meant he was prohibited from serving as lead counsel on any active case pending the inquiry's conclusion. The fraud charges against Claire were suspended. Not dismissed yet, the language was specific, and Sasha had explained the distinction clearly, pending the Oversight Board's review of the evidentiary foundation. And a county administrative audit had been triggered, covering the Housing and Social Services Coordination Office for the full period of Gerald Pratt's tenure, which meant that every decision made in that office during those years was now subject to examination. Fain had not been seen in the courthouse since the morning's emergency hearing. His office had issued a statement through an administrative aide that said very little and confirmed even less. The reporters who had been covering the case had shifted their framing entirely. The stories that had been about Claire Alderman's alleged fraud were now about something considerably larger, and several of them were on phones in the courthouse lobby trying to reach sources inside the county's administrative structure who were not returning calls. The man in the dark jacket had not returned to the courthouse. Dennis Pratt had issued no public statement. The county's legal department had responded to the records preservation order by producing the archive file at 3:45 in the afternoon, 45 minutes after the federal injunction failed, with a cover letter that described the production as voluntary and cooperative and used the word proactive, which was the kind of word organizations deploy when they are trying to get ahead of a narrative they know they cannot stop. Sasha received the file in the conference room and opened it on the table in front of Claire and Noah and Caleb, who had returned from wherever he had been and had the particular settled quality of someone who has completed a task that needed completing. The file was thicker than Claire had expected. 31 pages in the original. The restructured file in the system had 23. 8 pages were missing from the official record. They were here, in this folder, in the original. The missing pages were internal case notes written by the first supervisor who had reviewed Claire's guardianship application. They documented, in the careful neutral language of institutional record-keeping, a meeting that had taken place in month 11 between the supervisor and a representative from the Housing Coordination Office. The notes did not name the representative. They described the substance of the meeting as a discussion of pending cases in the Fenwick Park District and their relationship to future residential coordination planning. The final note, written 2 weeks after the meeting, read, "Per Coordination Office guidance, case to be maintained in active review status pending further direction. No finalization recommendation to be submitted without Coordination Office approval. No finalization recommendation to be submitted without Coordination Office approval." Claire read it twice. Then she set it down on the table and looked at the wall. Sasha was very still. Noah had stopped writing. That's it, Caleb said quietly. That's the instruction. Written in month 11, Claire said, before Brenda Holt ever submitted her recommendation, before Terry Owusu sent the guidance letter, before any of the 18 years that followed. Someone in the coordination office told the supervisor to hold the case before anyone had found a reason to hold it, Sasha said. And then that note was removed from the file that went into the system. But not from the original, Noah said. Not from the original. Claire was quiet for a moment. Outside the conference room, the courthouse had the late afternoon sound of an institution beginning to wind down. Quieter footsteps, fewer voices. The sense of a building letting out a breath it had been holding since morning. "Is this enough?" she asked. Not to anyone specific, to the room. Sasha answered. "This is more than enough for the charges to be dismissed. This is enough to demonstrate that the prosecution was built on a foundation that someone in county government helped manufacture." She paused. "Whether it's enough to result in criminal accountability for the people who built it depends on what the oversight board does with it and how far the audit goes." "How far will it go?" Claire asked. "Far," Noah said. He was looking at the note. "When an audit finds what this audit is going to find, it doesn't stop at the edges of what you were looking for." Caleb had his phone in his hand again. I was reading something with the flat processing stillness of someone receiving information he was already partially prepared for. He set the phone down. "The county's legal department just filed for appointment of an independent counsel to manage the audit," he said. "They're separating themselves from the internal investigation." "They're protecting themselves," Ethan said from the doorway. He had been standing there for the last several minutes. Claire hadn't heard him come back in. "Yes," Caleb said. "Which means they've already assessed that the audit is going to find things they don't want to be holding when it does." The room held that. "What happens to Claire right now?" Ethan asked. He was looking at Sasha. "Right now the charges are suspended," Sasha said. "Tomorrow morning I'm filing a motion for full dismissal with prejudice, based on the contents of this file and the conduct inquiry against Fain. Given what we have, I would expect the court to grant it within 48 hours. "Expect," Ethan said. "In law, that's as close to certain as I offer," Sasha said. "But yes." Ethan looked at Claire. She looked back at him. There was a conversation happening in that exchange that didn't require words and didn't need an audience. She looked back at the table, at the 31 pages, at the note in month 11 that someone had removed from a computer system and put in a drawer and assumed would never be found, because they had calculated, with reasonable confidence at the time, that no one would know to look for it. They had made that calculation about a woman who had spent a career in emergency medicine, where the difference between finding the thing everyone else missed and not finding it was measured in outcomes that could not be undone. They had also made it about 3 men who had grown up watching her work. The error was not in the calculation. The error was in the subject. Sasha was gathering the original file pages into an ordered stack when her phone rang. She looked at the screen and something in her posture changed. Not alarm, but the heightened attention of someone receiving information that changes the shape of the next several hours. She answered, listened, said 2 words, "How long?" and listened again. Then she set the phone down on the table and looked at the room. "That was Renata Voss," she said. "The Oversight Board has formally requested that the county clerk preserve all records related to the Fenwick Park development application filed by Orin Capital 4 years ago." She paused. "Including all communications between county officials and Orin Capital representatives going back to the original coordination discussions. That's everything, Noah said. That's the whole chain. Yes, Sasha looked at Claire. But Voss also said something else. She said the employee who accessed the archive file, the one who retired on the supplemented pension, contacted the oversight board this afternoon voluntarily. Nobody spoke. She's asking for a cooperation agreement, Sasha said. She says she has documentation of instructions she received in writing from Gerald Pratt's office. Instructions about which cases to access, what to remove, and what to replace it with. She picked up her phone. And she says there's a second set of files, not in the county archive, not in the county system at all. Where? Caleb asked. Sasha looked at him. She says Gerald Pratt kept his own copies, personal records, and she says Dennis Pratt has them. The conference room held the silence for 3 full seconds. He tried to seal the formation documents this morning, Noah said slowly, because he knew that once the audit started moving, it would reach those personal records eventually. He wasn't protecting the company, Ethan said. No, Caleb said. He was protecting whatever is in those files. He looked at his phone, then at Noah. If the oversight board gets a subpoena for Dennis Pratt's personal records before he destroys them, Voss is filing it, Sasha said. She's filing it tonight. And across the city, in an office building that Claire had never visited, and whose address she did not know, Dennis Pratt was either already destroying the thing that could finish this entirely, or he wasn't. And the difference between those two outcomes was going to be decided in the next few hours by people moving faster than he expected, through channels he had not anticipated, using records his father had kept in the private belief that they would never need to be used against him. Renata Voss filed the subpoena for Dennis Pratt's personal records at 6:47 that evening, and by 7:15 a federal marshal had delivered it to the offices of Pratt's legal team downtown with the particular efficiency that attaches to documents that carry the weight of an oversight board acting in concert with a federal referral. Whether Dennis Pratt destroyed anything in the hours between Warren Geld's phone call from the federal courthouse and the marshal's arrival was a question that the subsequent investigation would spend considerable time examining. What the investigation ultimately determined was that he had tried. A secure deletion protocol had been initiated on 2 devices registered to Orin Capital at approximately 3:20 in the afternoon, 40 minutes after the federal injunction failed. The deletion had been interrupted, not by the marshal, who arrived hours later, but by a data preservation order that Caleb's federal contact had filed through a parallel channel at 3:09, which meant the deletion attempt had been initiated 11 minutes after the preservation order had already frozen the relevant files. 11 minutes too late. Caleb did not explain to his family exactly how he had known to move that quickly. He said it was procedural and that the contact had been monitoring the situation and that it was clean, all of it was clean. And Claire looked at him across the conference room table and said, "I believe you," and meant it, and also understood that there were operational specifics in her youngest son's work life that she was better off not asking him to detail in a courthouse conference room at the end of a very long day. She had raised him to be honest, and she had raised him to be careful. She had not raised him to explain himself to everyone who was curious. Some things you do because they need doing, and you document them correctly, and you trust that the documentation will hold if it's ever examined. She understood that. She had operated that way herself for years, in a different context, with higher stakes. She picked up her coffee, cold now, had been cold for an hour, and drank it anyway. Well, the night passed the way nights pass when you are waiting for something you cannot accelerate. Clara went home at 9. Ethan drove her. He didn't talk much on the way, and she didn't push for conversation. They had always had that between them. The capacity to share a space without filling it, which was something she had modeled for them, partly out of her own nature, and partly because she had watched too many people in high-stress situations exhaust themselves on words that weren't doing any work. He pulled into the driveway and put the car in park, and sat for a moment with his hands on the wheel. "You should eat something real," he said. "I'll find something." "I can come in." "You don't need to." A pause. "I know I don't need to." She looked at him. In the dark of the car, with the porch light throwing its limited reach across the driveway, he looked the way he had looked at 17 when he was trying to figure out how to be both the oldest and not the one in charge, which had been its own complicated negotiation across the years they had all lived in this house. He had never entirely resolved it. He was still negotiating it now, in a different form. The shape of the negotiation had changed, But the underlying question was the same. How much of the carrying do I do, and how much do I leave for her to carry herself because she needs to? "Come in," she said. "I'll make eggs." He came in. She made eggs. They ate at the kitchen table with the box from the hall closet still there, reordered and relabeled, and neither of them talked about the case for the 40 minutes they ate and washed the dishes and sat with what remained of their respective coffees. They talked about Marcus, Claire's son, who had called that afternoon from Portland, and who had been following the news coverage, and who was, Ethan reported, extremely irritated that nobody had called him sooner. They talked about a problem Ethan had with a subordinate officer back at his post that he'd been dealing with for 3 months and hadn't resolved, and that he'd been carrying around the way people carry things they haven't had time to address because other things kept being more urgent. Claire listened and asked one question and did not offer advice he hadn't asked for. He left at 11:30. She stood on the porch and watched his rental car back out of the driveway and disappear down the street. Then she went inside and sat at the kitchen table and was, for the first time in 4 days, completely alone with the quiet. She had expected to feel some version of relief. She had expected the weight she'd been carrying since the charges were filed, the specific grinding weight of being publicly accused of something you didn't do by people with institutional authority to make the accusation stick, to have lightened somewhat given the day's events. It had lightened, but not in the clean, uncomplicated way she had perhaps imagined it would. The lightening was more like the feeling in a limb when circulation returns after a long compression, not comfort immediately, but the complicated, slightly painful process of restoration. She had been wronged. The machinery that had wronged her was in the process of being dismantled. Neither of those facts produced the particular satisfaction she suspected they might have produced in a person whose accounting of events was simpler than hers. What she felt mostly was tired, and underneath the tired, something she was still identifying. She thought about it for a while. Then she pulled the legal pad toward her, opened it to a blank page, and wrote one line at the top, "What I know how to do." She sat with that for a moment. Then she started writing. The motion for dismissal with prejudice was filed at 8:15 the following morning. Sasha had drafted it through the night, incorporating the archive file's original case notes, the access log entries, the retired employees' cooperation agreement, and Voss's preliminary findings from the Oversight Board's review of the Pratt memo and the Harwick Meridian Group Coordination records. It was 63 pages. It was, in Noah's assessment, the cleanest piece of legal argumentation Sasha Brent had produced in 19 years of practice, and he told her so, and she told him that compliments from opposing counsel made her nervous, even when the opposing counsel was technically on her side now. Judge Merck received the motion at 8:15. He read it in his chambers with Dana Ferris present and his door closed. At 9:40, he called both parties for a hearing at 11. Douglas Fain did not appear. His office sent a notification that he was recused from the case pending the bar inquiry and that the state attorney's office had not yet appointed a replacement. The notification arrived 12 minutes before the hearing was scheduled to begin. The state attorney's office, it turned out, was not going to appoint a replacement. What they were going to do, and what the chief deputy state attorney communicated to Merck's chambers by phone at 10:50, was indicate that the state was not prepared to defend the charges as filed given the Oversight Board's preliminary findings, and that they were not opposing the dismissal. Merck called the hearing anyway. He said later, in a statement that was quoted extensively in the Calverton Ledger's coverage of the case, that he believed the record deserved a formal proceeding rather than an administrative notation, and that Claire Alderman was owed a courtroom and a judge and a spoken ruling rather than a letter. Whether this represented genuine conscience or an attempt to manage how history would record his role in the proceedings was something that different people assessed differently. Claire, when asked about it later, said she neither knew nor spent significant time thinking about it, which was the honest answer. The courtroom at 11 was full in a way that the earlier sessions had not been. The gallery had people standing at the back. The Fenwick Park contingent had grown from the original cluster to something that occupied 4 full rows. Donna Fitch was there. Margaret Boyle was there. Patricia Holm was there, in the same seat she had occupied on the first day, and this time she had brought her sister. The reporters were there, more of them than before. The story had changed shape overnight in the way that significant stories do when The institutional scaffolding holding them in one form begins to come apart. It was no longer the story of an elderly woman accused of fraud, and the people covering it had updated their framing accordingly. Claire sat at the defense table with Sasha on her left and Noah on her right. Ethan and Caleb were in the gallery, first row, directly behind her. She had not asked them to sit there. They had simply placed themselves there when the room filled, and she had felt the particular quality of their presence, the way you feel the presence of a wall at your back when you are standing on uncertain ground. Not because you need to lean on it, but because knowing it is there changes how you stand. Merck entered, and the room came to order, and he sat and looked at the motion on his bench, and then looked at Claire and said, "Ms. Alderman, will you please stand?" She stood. He looked at her for a moment. Not the look of the first day, not the look of a man who has decided, but the look of someone who is in the process of understanding something that requires the understanding to be spoken aloud to be complete. The court has reviewed the motion for dismissal with prejudice filed by the defense, the preliminary findings of the County Oversight Board, and the state attorney's notification that the state does not oppose this motion. He paused. The charges of benefit fraud against Claire Alderman are dismissed with prejudice. The record of these proceedings will reflect that the charges were brought on a foundation of evidence that had been materially altered by persons acting outside the authority of this court, and that the defendant's actions over the 18-year period in question were consistent with the guidance she received from county officials and the documentation she maintained throughout that period. Another pause. This court also notes, for the record, that Ms. Alderman sustained care for 3 children over nearly 2 decades under conditions that included deliberate administrative obstruction, represents a standard of commitment that is not reflected anywhere in the charges that were filed against her. He looked at her directly. "You are free, Ms. Alderman. I'm sorry for the time this cost you." It was not a perfect apology. It did not account for the handcuffs on the first morning, or the photographer on the courthouse steps, or the 2 days of sitting in that room while her name was attached to the word fraud in front of people who had known her for years. A courtroom apology delivered by a judge who had not distinguished himself in the early stages of the proceedings could not carry all of that weight, and Claire did not expect it to. But it was spoken, in a room full of people, on the record. She said, "Thank you, Your Honor." She sat down. Behind her, she heard the gallery, and she heard, unmistakably, through everything else, the sound of Donna Fitch exhaling, which was the sound of someone releasing something they had been holding for days. The public accounting came in pieces over the weeks and months that followed, and it was messier and slower and more incomplete than the version of justice that exists in the imagination, because real accountability almost always is. Douglas Fain surrendered his law license 11 weeks after the bar inquiry opened. The inquiry's findings were made public in a 40-page report that documented his failure to disclose the financial connection to Orin Capital, his receipt and suppression of materials submitted by the defense prior to trial, and his knowing prosecution of charges that his own pretrial investigation had revealed were built on administratively compromised evidence. The report used the word knowing 4 times, each time with documentation attached. He did not make a public statement. His attorney issued a brief notice that described the surrender as a decision reached after careful reflection, which was the kind of language that means nothing and is intended to mean nothing. The county audit ran for 7 months. It examined 14 years of Gerald Pratt's tenure in the Housing and Social Services Coordination Office and found irregularities in 31 cases, of which 9 involved circumstances similar to Claire's: guardianship or foster placement cases in residential areas that had been the subject of development coordination discussions, kept artificially unresolved through a combination of case restructuring, supervisor direction, and selective document management. The audit findings were referred to the county prosecutor's office, which opened a criminal investigation. Dennis Pratt was charged with obstruction of justice, evidence tampering, and conspiracy to commit fraud against the state. The charges were filed on a Tuesday morning and carried to the press by the county prosecutor's office with a detail and specificity that suggested they had been preparing the announcement for some time. The personal records recovered from Pratt's devices included 11 years of communications between Orin Capital and various county officials, 3 of whom were named in the charges as co-defendants. The communications were, in the words of the Oversight Board's final report, unambiguous in their intent and comprehensive in their documentation of a coordinated effort to manage county administrative processes in the interest of private development objectives. The Fenwick Park development application was formally withdrawn by Orin Capital 3 days after the charges were filed, which was not a surprising development, but was noted by many of the Fenwick Park residents who had spent 4 years fighting it. The retired employee who had accessed the archive file cooperated fully with the investigation. Her cooperation agreement protected her from criminal charges in exchange for complete disclosure, and her disclosure was, by the investigation's assessment, complete. She gave the names of the people who had given her instructions, the dates on which instructions were given, and the locations of additional documentation she had retained over the years in the private calculation that she might someday need protection of her own. It turned out she had been right about needing it. The documentation she provided became the foundation of 2 of the 3 most significant charges in the criminal filing. She was not a hero in this story. She was a person who had made choices she should not have made and had eventually, for reasons that mixed self-interest with something that might have been closer to conscience, made a different one. That was not redemption exactly, but it was something that had a consequence, and consequences were what the situation required. 3 months after the dismissal, the county's Social Services Department announced the creation of a new case oversight program that would require independent review of any guardianship or foster placement case that remained unresolved after 4 years. The program was proposed by a subcommittee that had been formed following the audit findings. The subcommittee's chair was a woman named Phyllis Okafor, who had retired from Whitfield Regional Medical Center's Family Advocacy Office 2 years earlier, and had apparently not retired from the underlying work. She called Claire to tell her about it. "They're naming it after you," Phyllis said. "The Oversight Program. They want to call it the Alderman Review Standard." Claire was in her kitchen when the call came. She was standing at the counter, which was where she took most of her phone calls, a habit she had never examined closely enough to understand. "Tell them to name it after the children it's supposed to protect," she said. "Not after me." Phyllis was quiet for a moment. "I'll pass that along. They might do it anyway." "They can call it whatever they want," Claire said, "as long as it works." "It'll work," Phyllis said. "I'm going to make sure of it." Claire believed her. The ceremony that the city organized was smaller than the county had initially proposed, at Claire's specific request, and was held in the community room of the Fenwick Park Neighborhood Center rather than in a formal venue downtown. This was also at her specific request. She had been asked 3 times by the county communications office if she was certain she didn't want a larger venue, and each time she had said yes, she was certain, which in her experience was the clearest way to communicate that a decision had been made. The room held 80 people comfortably and had 94 in it on the day of the ceremony, which meant a number of people were standing at the back and along the side walls, and that the building's ventilation system was working harder than it was designed for in November. But nobody left early and nobody complained about the temperature. The county commissioner who presented the citation read from the document in full, which took 4 minutes and covered 30 years of emergency nursing at Whitfield Regional, the care of 3 children over nearly 2 decades, and Claire's role in exposing what the commissioner described as a sustained abuse of administrative authority that had harmed vulnerable residents across the county. He used the word courage twice. Claire did not particularly like the word courage in this context because it implied that what she had done required a quality she wasn't sure she possessed in the way the word suggested. What she had done had required stubbornness and record-keeping and the willingness to stay in a situation that was uncomfortable until it changed. Whether that was courage or just the particular shape of her personality was a distinction she found more interesting than the word itself. She accepted the citation. She shook the commissioner's hand. She stood at the front of the room with Ethan to her left and Noah and Caleb to her right and looked at the 94 people in a room built for 80 and felt the weight of the moment without being consumed by it, which was how she had always felt the weight of things. She had been asked to say a few words. She had prepared something. Then she had set it aside and decided to say what she actually meant. "I kept those boys because someone had to," she said. "I kept fighting this case because someone had to. I kept every piece of paper for 18 years because I worked in emergency medicine long enough to know that the thing you think you'll never need is always the thing that matters later." She paused. "I'm not standing here because I'm special. I'm standing here because I didn't stop. And I had 3 people who didn't stop either, and a lawyer who worked through the night, and a caseworker who never let go of the case. and a woman in a records office who eventually found her way to the right side of something. She looked at the room. That's not a hero story. That's what happens when ordinary people refuse to accept that ordinary is the same thing as helpless. The room was quiet for a moment. Then Donna Fitch started clapping, and the sound filled the room the way sound fills a space that has been waiting for it. She drove home alone afterward because she had asked Ethan not to follow, and he had respected it, which she appreciated. She needed the 20 minutes of the drive to transition from the public version of the day to the private one, and she had always made that transition better in motion than in stillness. She parked in the driveway and sat for a moment with the engine off, the way she had sat on the night of the first day of the trial. The porch light was on. She had left it on when she went out, the old habit from the years when she had needed it to be on for 3 specific reasons, who came home at different hours and from different directions. She sat there for perhaps 5 minutes, not thinking about anything in particular, just sitting in the specific quiet of an ending that was also, in some way she hadn't fully mapped yet, a beginning. The legal pad she had written on that first night was still on the kitchen table. She had added to it over the past weeks. Not a plan exactly, but a working document. What she knew how to do. What the audit had revealed about the gaps in the system for children in transitional placements. What Phyllis's oversight program would need in its first year. What she could offer that a committee or a policy document couldn't. She had spent 30 years in emergency medicine because the emergency room was where the system's failures arrived with faces and names and urgency that couldn't be abstracted into process. She had raised 3 children for the same reason, not as a policy position or a civic act, but because 3 specific people needed someone specific to stay. She understood, sitting in the driveway at the end of a day that had taken 18 years to arrive at, that this was the common thread. Not heroism, not sacrifice in the grand, narrated sense, just the specific willingness to look at a problem with a face on it and not look away. She was 73 years old. She had been a combat medic, an emergency nurse, a guardian, a defendant, and apparently now a standard. She was tired in the way that people are tired after a long effort that has finally reached its conclusion, not depleted, but spent in the way of something that has been used for the purpose it was made for. She got out of the car. She went inside. She hung up her coat and put on water for tea and sat at the kitchen table with the legal pad and picked up her pen. She had work to do. Not because anyone had given it to her. Not because a ceremony had named her and now she was obligated to perform something that matched the name. But because on a Tuesday morning 19 years ago, she had stood in a doorway and looked at a problem and asked what needed to happen next. And that instinct had not stopped being true just because one particular chapter of it had reached its resolution. The tea was ready. She poured it. She set the cup beside the legal pad and looked at what she had already written. Then she turned to a fresh page and started. The systems that fail people rarely fail them all at once. They fail them in small increments, in quiet rooms, in decisions that are individually defensible and collectively catastrophic. They fail the people who don't have someone watching. They fail the people who don't know what paperwork to file, or who to call, or how long to keep calling before the call is finally answered. They fail the people who have been made to feel that the complexity of a process is evidence of their own inadequacy rather than evidence of a system that was never designed with them in mind. She had spent 40 years in rooms where people arrived at the worst moments of their lives and needed someone to stay with them through it. She had spent 18 years making sure 3 specific people had someone staying. She knew, in the particular way you know things that have been earned rather than learned, what it meant to be the person who stayed. She also knew what it meant to be the person everyone assumed would not fight back. They were never the same person, in the end. She had spent 73 years proving that. Outside, Calverton was doing what Calverton did in November, settling into the cold and the dark with the patient, indifferent endurance of a place that has seen many things and intends to see many more. The porch light was on. The tea was warm. The legal pad had room for many more pages. She kept writing. Caleb left on a Wednesday in late January without making much of it, which was consistent. He came downstairs with his bag already packed, said he'd be in touch, accepted the coffee she had ready because she had known he was leaving that day, and got into his rental car. He rolled down the window before he pulled out of the driveway. "The 6 other people," he said, "the ones from the other counties. The federal team made contact with all of them last week." "How are they?" she asked. "Scared," he said. "Relieved. Confused. Someone showed them the Calverton case as context, and most of them wanted to know how you kept going without knowing anyone was looking. She thought about how to answer that. Not the version of the answer she'd given Ethan in the conference room, but the real version. The one that existed underneath the language of floors and steadiness and useful things to do in a crisis. "I wasn't keeping going for a reason," she said finally. "I was keeping going because stopping felt wrong. Because there were 3 kids in my house who needed someone to still be standing in the morning. Because somewhere in the process of trying to do one ordinary thing correctly, it became the thing I couldn't put down." She looked at her son across the hood of the rental car. "Tell them that. Tell them it doesn't require certainty. It just requires not stopping." Caleb looked at her for a moment. Then he nodded once, the way Ethan had nodded in that plastic chair at 7 years old, and pulled out of the driveway. She stood in the cold and watched the car reach the end of the street and turn. The program, officially titled the Guardianship Navigation Program, unofficially called by the staff within 6 months. Simply the Alderman Program, opened its intake office on a Monday morning in March in a building 3 blocks from the County Social Services Department. Claire was there for the opening, not to cut a ribbon or give a speech, but to sit in the intake room with the first 3 clients and walk them through the paperwork. The first client was a woman of 48 who was attempting to establish guardianship for her nephew after her sister had been hospitalized. She had been given 3 different forms by 3 different departments and was not sure which one applied to her situation. Claire looked at the forms and sorted them in approximately 4 minutes and explained in plain language exactly what each one was for and what order to submit them in. The woman looked at her. "How do you know all this?" "I've made every mistake it's possible to make in this process," Claire said. "It's useful." The second client was a man of 63 attempting to formalize arrangements for 2 grandchildren he had been informally caring for. He was quiet and skeptical and had the look of someone who has been failed by institutions enough times that entering a room affiliated with one is a deliberate act of will. Claire did not oversell the program. She told him what it could and couldn't do, what his options were at each stage of the process, and what to do if he was told something that didn't match the written policy. He asked, at the end of the meeting, "And if they stall it, like they did with you?" She looked at him. "Then we document everything. We escalate through every channel available, and we do not stop." She paused. "And if they do it anyway, you have someone in your corner who has been through it and knows exactly what the stalling looks like from the inside." He looked at the table for a moment. Then he said, "Okay, that was enough. But there is something that people do not often say about this kind of story because it requires sitting with a discomfort that doesn't resolve neatly. The discomfort is this. The system that was used against Claire Alderman was not exceptional. It was not a bizarre aberration operated by uniquely villainous people. It was the ordinary machinery of institutional process, operated by ordinary people making calculations about risk and benefit and the probability that someone would notice. And those calculations had been wrong about her specifically, but had probably been right about a great many other people who did not keep 47 folders, or have 3 sons who learned to fight for what was right from someone who had no business being quiet and had been quiet for a long time anyway. What Claire understood, sitting in that intake room on a March morning with 2 clients who were scared and skeptical and trying to do something ordinary in a system that was not built to make ordinary things easy, was that the point was never the courtroom. The courtroom was the consequence. The point was the 18 years before it, the filing and the calling and the driving to offices and the late nights at the kitchen table and the absolute refusal to accept that the process not working was the same thing as the process having been given a fair chance. She had been underestimated at every stage, as a nurse who didn't know law, as a woman without resources, as a person without connections, as someone who had buried her military past so completely that no one thought to look for it. She had been assessed at each of those angles and found wanting, and every time someone had looked at her and seen something smaller than the threat she actually was, they had made a choice that moved them closer to where they ended up. That is not a triumphant observation. It is just true. And the truth of it is useful if you are standing at the beginning of something that looks impossible and you cannot see the end of it, and someone has recently assessed you and found you wanting. The assessment is not the verdict. The verdict is made over time, by the accumulation of what you do next, and the people doing the assessing do not always get to be present for it. Claire Alderman was 73 years old. She was tired in ways that sleep had not fully addressed and probably wouldn't. Her lower back still did the thing it had started doing during the trial, and she had finally seen a doctor about it, who had told her something manageable and not alarming. She had a program to run, and 3 sons who called regularly, and a granddaughter who had sent her a letter in the mail, an actual letter, on notebook paper, with a drawing of the courthouse at the top, that said, "Grandma Claire. I told my class about your case. My teacher said you were brave. I said you were stubborn. She said those are usually the same thing. Love, Iris." She had kept the letter. She put it in the box, in the front, next to Ethan's note. The box was in the hall closet again, behind Marcus's old tennis racket and the bag of winter gear she was still meaning to sort through. She would get to it eventually. She was not finished yet. That was the thing. That was the thing that the people who had looked at her and seen something small had most completely failed to understand. She had never been finished. Not at 73. Not in handcuffs in a marble corridor. Not in a conference room at 3 in the morning with bad coffee and a legal pad and a thread she could feel but couldn't see yet. People who have spent their lives being the floor for other people to stand on do not run out. They learn, if they are lucky and if the right people show up, to let someone else take the weight for a while. They learn that staying is not the same as carrying everything alone. They learn that the children they raised and the neighbors who showed up and the attorney who filed a 41-page motion at 4 in the morning are part of the same floor. That floors are not made of one person's refusal to collapse, but of many people deciding, separately and together, that the thing under their feet is worth holding up. She had spent a long time not knowing that. She knew it now. And on a Monday morning in March, in a small intake room 3 blocks from the county social services department, she sat across from a woman she had never met before and helped her sort 3 forms into the correct order. And it was not a dramatic thing, and it was not a public thing, and it was exactly enough.